In this lecture, we will be discussing easements, the lines with Chapter 10 of your textbook. An easement is a non-possessory right to use the land of another. Now, what differentiates an easement from a lease is that it is a non-possessory right to use. So with a lease, the tenant has the right to possess someone else's land. With an easement, there is no right to possess the land. It is just a right to use the land of another. Now, an easement is not the only type of non-possessory right to use the land of another. There is also something called a license that is briefly viewed in your book. I just want to again emphasize the difference between an easement and a license. An easement is typically thought of as something that it flows with the land. So when a piece of land is transferred, the easement continues with land. A license, on the other hand, it is revocable. It can be revoked at any time. All right. Licenses also can be personal and not something that necessarily needs to travel with or be attached to the land. So an individual can be given a license to enter the land of another and to, for example, harvest crops. But that license can be revoked or withdrawn at any time. Now, this differs from an easement because an easement is something that flows with the land, and it does so typically for an indefinite time. Now, there are various forms of easements. There are express easements, implied easements by prior existing use, easements by necessity, prescriptive easements, and easements by estoppel, or some jurisdictions call it an irrevocable license. Now, I'm going to go over each one of these, and we're going to talk about a case that helps illustrate each of these different types of easements. So we're going to start with the express easement. An express easement is an easement that is in writing, and it is given by one landowner expressly to another. Now, the landowner that gives the easement is considered the servient landowner, and they give the easement to the dominant landowner. Now, because it is in writing, it satisfies the statute of frauds. Next, we're going to take a look at a case that introduces the express easement. And the issue in this case is whether an ambiguous agreement created an express easement or a revocable license. So the facts of the case are as follows. The plaintiff, Millbrook Hunt, Inc., engaged in fox hunting. They entered into a contract, an agreement called Lease and Easement Agreement with the owner of 285 acres of land. So, under that agreement, Hunt Inc. leased a quarter of an acre of parcel, and the lease term was for 75 years. And that agreement contained a clause that allowed Millbrook Hunt Inc. to hunt foxes on the rest of the land during this period, the 75-year period. This same agreement also said that the owner of the land would have the absolute right to develop the land as they see fit. So we have some ambiguity here, because if the owner wants to develop the land in a way that terminates the Millbrook Hunt Inc.'s ability to hunt foxes, then does that mean that what was granted to Millbrook Hunt Inc. was a license that could be revoked? So anyway, this agreement was recorded, and it was later purchased. The land was later purchased by Smith. And Smith wanted to preserve nature, and he did not want, or they did not want there to be any hunting of animals. So they ejected Millbrook Hunt Inc. from the land. Hunt then sued for a declaration that it had an easement over the land, and thus that easement couldn't be revoked. The trial court granted summary judgment for Hunt, and here the New York Supreme Court affirms that judgment. In its analysis, the court first notes on page 688 that to determine the true character of an interest, i.e. whether it's an easement or a revocable license, the court must examine the nature of the right rather than the name given to it by the parties. So in other words, here the court is going to, has decided that they're going to look at not just what the parties have called this this non-possessory right, but they're going to look and see what the nature of that right is. They then say that an easement implies an interest in the land that's ordinarily created by grant and is permanent in nature. And this differs from a license because a license, again, is like I said, a personal privilege to commit some act or series of acts on the land of another. All right, so again, here's that distinction between an easement and a license. An easement implies an interest in the land that is permanent, whereas a license can be attached to a person and can be revoked at any time. Now, despite easements being more permanent in nature, you can have an easement that is for a term of years or for a designated period of time. And so the court says that that is what happened here, that there is an easement that is allowed for the 75 years. And so, as such, they find that Millbrook Hunt does indeed have an easement and not a revocable license. I'd also like to point out a couple more things about the case. The first is that note that the easement in this case attaches to the land, because easements always attach to the land. What does that mean? Well, it means that we had the original owner and then we had the subsequent purchaser. And when the owner sold to Smith, the purchaser, the easement flows and continues with the land. So it remains a condition, it remains an encumbrance that flows with the land. So that's the first thing. The second thing to note is that the easement was recorded. So Smith couldn't claim that he was a subsequent bona fide purchaser without notice, right? The easement was recorded, and because it was recorded, Smith was on notice before he purchased the land that the land had this easement on, this encumbrance on it. Had the easement not been recorded, then Smith would have had a case to argue that he purchased the land as a bona fide purchaser, and the encumbrance did not flow with the land. But again, here there was a recording, and so Smith had notice, and easements attached to the land and flows to subsequent purchasers. Finally, we have an express easement here because it's in writing, and although it was ambiguous, it did communicate the terms that the parties understood as they understood them to be under. This next case that we're going to discuss deals with an implied easement by prior existing use. An implied easement is an easement that's created after an owner of two parcels of land uses one parcel to benefit the other parcel to such a degree that upon the sale of the benefited parcel or the dominant parcel, the purchaser could reasonably expect the use to be included in the sale. Now let's take a look at a case that involves an implied easement. And that case is Emanuel v. Hernandez. So the Emanuels owned a home that was or is adjacent to the Hernandez home. Before the Hernandezes purchased the home, the Emanuels for 35 years had used this driveway to access this garage. Now, as you can see from this lot line right here, most of the driveway is on the Hernandezes' property. But the Emanuels claimed that this was the only way that they could access their garage, and without using this driveway, they wouldn't be able to use the attached garage. When the Hernandezes purchased the home, they began blocking this driveway. They then started constructing a fence right here on the property line so that the Emanuels would not use the driveway. So the plaintiffs, the Emanuel, they sought a declaratory judgment seeking that the court hold that an implied easement by prior existing use over this driveway right here. The trial court granted summary judgment for them. So why did the trial court grant a summary judgment for the plaintiffs? Well, there was quite a bit of evidence that was before the trial court, including an affidavit from the Garrigans who sold the house to the Emanuels. And the Garrigans said that they used the same driveway from 1953 onward. Then there was an affidavit from the Emanuel's lawyer that said that the title to the lots that are now owned by both of these parties was once owned by someone by the name of Brock. And Brock partitioned the properties, sold one lot in 1890, and then sold the other lot. So that was why the trial court issued the summary judgment. Now, the appellate court, which is the opinion that we're reading, reversed this decision. All right, let's take a look at the elements for easement by implied pre-existing use in Illinois, the ones that were applied in this case. They are as follows: that common ownership of the dominant and the servient parcels and a conveyance or other transfer separating that ownership. The second is before the conveyance or transfer severing the unity of title, the common owner used part of the united parcel for the benefit of another, and that this use was apparent, obvious, continuous, and permanent. And the claimed easement is necessary and beneficial to the enjoyment of the parcel conveyed or retained by the grantor or transferor. Well, the court felt that the plaintiffs were able to show element 1, because if you remember, they showed that Brock owned both parcels. They were also able to prove element 3, which claimed that the easement was necessary and beneficial, right? Because if we go back, without this easement, they won't be able to use this garage. But the court felt that the second element of the implied easement statute or implied easement rules were not met. And that is that before the conveyance or transfer of the severing unit, the common owner used the parcel for the benefit of the other. So the court felt that there was not enough evidence showing that Brock over here actually used this driveway for the benefit of this parcel. And without this evidence, the court found that the summary judgments, all elements were not met, and summary judgment was not appropriate. Now, if the plaintiffs are able to prove this second element, then the outcome of this case will be different. Now, a couple more notes on implied easements before we move on. So one of the elements here is that this easement is reasonably necessary, right? Reasonably necessary. So what does reasonably necessary mean? Well, reasonably necessary or reasonable necessity does not mean that it must be essential. It just means that it must be beneficial or convenient. Okay, so you can prove what is necessary, what is necessary by showing that it is beneficial or convenient. The second point I'd like to make is that a grant or a reservation can be used to create an implied easement prior to existing use. A grant, so in this case, the plaintiffs are arguing that there was a grant, implied easement by grant. But a reservation would mean if, when Brock sold the first property, or when Brock sold this property here, he retained or reserved this right for this parcel. All right? So that's the difference between a grant or a reservation. These are two ways that this implied easement could be created. All right, we're going to move on to the next type of easement, an easement by necessity. An easement by necessity is created by law because the easement is indispensable to the reasonable use of nearby property, such as an easement connecting a parcel of land to a road, for example. So the key difference here is that we're talking about something that is indispensable. Okay. For the finding of an easement by necessity, a court typically requires two elements. The first is that there is severance of title to land that is held in common ownership. So, in other words, we have owner initially owns both parcels as one and then subdivides the parcels and sells them off individually. And the second requirement that there was a necessity for the easement at the time of the severance. So at the time that O separated the two parcels, there was necessity at the time. Okay, so to explore easement by necessity, we're going to take a look at a case called Burge v. State of Vermont. The issue in this case is whether necessity exists if the property can be reached by boat. The facts of the case are as follows. In 1959, a man by the name of Davis conveyed over 7,000 acres of undeveloped land to the state of Vermont. Now, Davis retained 38 acres, and that 38 acres did not have any, when she did that, she didn't reserve any express easement along with it. As a result of Davis's conveyance, the 38 acre parcel that they reserved became landlocked. In other words, it could not be accessed anymore. There was no road that allowed access to the land without going over someone else's property. That's what landlocked means. All right. So in 1961, Davis then conveyed that 38-acre parcel to McDonald and Washburn. And McDonald and Washburn created a subdivision. They subdivided that lot and they sold it for people to build homes on. So in 1997, that's when Berg purchases the property. Berg purchases 2 of these 18 lots. Now, Berg regularly used a gravel road that began on what's called State 114, and it ran across the state of Vermont's property to Berg's property. Now, the only other way to access Berg's property was by using a boat, because the land was landlocked, but it could be accessed by water. So eventually the state placed a gate across that gravelly road, and Burge was no longer able to use it to access their land. So Burge filed an action to assert that they had an easement by necessity over the wildlife preserve the state of Vermont owned. The trial court granted the state's motion for summary judgment, and it found that because Burge could reach the land by water, then it meant that they had access to their land, and so they were not able to prove necessity. That gravel road wasn't necessary in order to access the land. They could access the land via boat and water. So what we're reading here is an opinion by the Vermont Supreme Court, and they reversed the trial court's decision. In their ruling, the court distinguished between what they considered extreme inconvenience versus necessity and not convenience. And they opined that mere inconvenience was not enough to show necessity. However, in their definition of what is necessary, it has to include this idea of what is practical. The court felt it was not practical to expect Burge to access their property only by water, not in this day and age. So they held that they should, quote, not freeze the common law in time and interpret necessity to also include situations in which land was landlocked but was also accessible by water. So the court found that just because the land was accessible by water, that was not sufficient access, and that a finding of necessity was indeed warranted. Now I want to talk a bit about the difference between the implied easement by prior existing use and an easement by necessity. Now, both an implied easement by prior use and an easement by necessity requires common ownership, right? So in both of the two cases we just looked at, there was one owner that subdivided the property. But there is a difference in going back. Oh, went back too far. Okay. So we have the common ownership. This is the implied by pre-existing use. Now, the second element requires that before the severance, the servient estate was being used to benefit the dominant estate by the original owner. All right, so I'm going to repeat that. The original owner needs to have used the servient estate for the benefit of the dominant estate in the same way that it's being contemplated to be used in the present case, right? Now, that is not required for an easement by necessity. It is entirely possible that the necessity did not occur until the time of severance, but it needed to occur at the time of severance. So what does that mean? Well, typically what that means is, let's say we have a plot of land that looks like this, and there's water over here, and there's water over here. So originally, owner owns all of this property, okay? All of that property. And perhaps owner did not use this, so let's say this is lot A, B, and C. Perhaps the owner didn't use C to get to lot A, right? But when the owner subdivided the lots like this, A became landlocked. So at the time of severance, there was a necessity to access it. So again, the difference is the implied easement by prior use requires prior use of the easement, okay? And it also requires reasonable necessity. Whereas here we're talking about just necessity, and that necessity is usually created at the time of severance. I hope that clears up. All right, let's end here with a thought question. What do you think are the policy justifications for an easement by necessity?